First of all, I believe I must thank Deloitte for organizing an important event like this. So on the 22nd, we intend to briefly explain the importance of this amendment, specifically Amendment Act number 12 of 2025. And I believe the interest groups would be companies, boards of directors, shareholders, the people who deal with the registrar of companies, and especially the company secretaries, whose role is to liaise with the ROC or the registrar of companies. The whole purpose of this amendment is the importance of beneficial ownership. Now, this is something which we did not think of when we were drafting the current Companies Act number 7 of 2007, way back in 2007. This plus the insolvency laws were not looked at because quite a lot of new developments were taking place at that time, and now there will be another amendment, if at all, that would come with regard to the insolvency laws. But this particular amendment, which came into operation in August 2024, is of importance to these respective people I mentioned, especially the company secretaries, who would have a bigger role to play to liaise with the registrar of companies and the world at large. Now, the whole purpose of this amendment is to come in line with international developments on these fields, especially the beneficial ownership of shares. As you are aware, the beneficial ownership of shares is something where you try to hide the actual owner's name and details. Now, world over, even in the Swiss accounts now, they don't intend having numbered accounts, they want the identity of the person. So in Sri Lanka, though rather late in the day, we are also following suit in developed jurisdictions, where we want to have a very transparent mechanism in our corporate law statute, wherein the company, the shareholders, the company secretary and the registrar of companies will be held responsible for details of the beneficial ownership of shares, and especially to maintain registers, the timelines drawn up, what are the responsibilities of these individuals I just mentioned, and then what are the responsibilities of them vis-a-vis the third parties who will want to get information, I mean the public, the regulators, maybe third party officers with regard to certain regulatory functions, and the public at large. Even after the RTI, the Right to Information Act, came into operation, now even the public can look into certain matters of corporate bodies. So likewise, whether it's the public sector or the private sector or any other bank or whatever organization, it is best for the players to know what compliance is all about. As you are aware, most of the banks and other regulatory institutions rely on compliance. In banks, a compliance officer is a must, it's mandatory. Now for companies, it is not a must, but most of the listed companies have compliance in big way. The related party transactions is something that arose from the corporate governance mechanism. So this again is to strengthen corporate governance in the organization. So main importance of this amendment is focused on the beneficial interest of shares. Now that has to be very transparent and very clear. We have amendments brought in under section 130 of the Companies Act. 80 subsection 130 subsection A to J would deal with the details of what beneficial ownership and what these players have to do and their individual responsibilities are, and the timelines and so on and so forth. There are a couple of regulations that has to come pursuant to this act coming into operation. The minister will have to draft the regulations and put into place. That's yet to come. Maybe in a couple of months the regulations will come into play. But I'm thankful to the organizations which prompted this, and also in addition there are a couple of other areas where to streamline, like the directors extension of the 70-year rule, how specific it should be. Then with regard to removal of a director, how transparent it should be. You have to give a proper opportunity to the directors to say whatever before the shareholders and all the shareholders to know, and clarity in certain areas like single shareholder companies, distributions, so on and so forth, and a whole lot of amendments that are coming in which were in the pipeline for a long time with regard to typographical errors in the Act. So all in all, it's important for anyone who is related to a company, whether it's a company, a director. When I say a director, it can be executive directors, non-executive directors, independent directors, so on and so forth, and also senior officers, and specifically I must mention the company secretary, because the company secretary is the person who liaises with the registrar of companies vis-a-vis all company matters with regard to documentation. So ROC is the repository of the documentation for companies, and so these people will be responsible, and in addition the registrar of companies is also responsible in certain matters with regard to third parties and so on, and maintaining registers. And it's a new feature that is coming into in application to our corporate governance and corporate the landscape of corporate world, which we have had the from 1861 we have had the Joint Stock Companies Act, we have had the 1938 ordinance, we have had the Companies Act of 17 of 1982, and the current Act is 7 of 2007. So this is a landmark which brings in a very important amendment, and I beg the audience who will be there on the 22nd to take note of the important factors so that they can again help their own companies and even in your individual companies to make it more transparent and the corporate governance to be more effective.